Let's say that your immigrant spouse has a tourist visa and you go to her country and you guys get married. And then after you get married, your immigrant spouse is coming to the United States as a tourist. Hey guys, Puyan Darian here, immigration lawyer, here to talk to you today about whether you should get married abroad or in the United States if your immigrant spouse has a tourist visa or ESTA and is able to freely travel back and forth. And I guess this would also apply to people who have any sort of non-immigrant visa, like a student visa. We're going to be talking about why the question by itself is problematic, some concerns, and maybe even some tips or considerations that you should be thinking about along the way that'll help you guys as you plan your futures together. Why did I say that the question itself is problematic? Well, it actually comes down to one phrase: fraudulent intent. You cannot enter the United States with a non-immigrant visa, like a tourist visa, as F1 student visa, if your plan at the moment of entry is to actually permanently reside in the United States. In fact, in the airport or whatever port of entry where you're trying to enter the US, if the customs officer believes that your plan is to permanently live in the US, they are supposed to deny your entry and possibly even cancel your visa. And if you flew in, that means that the airline will be responsible for a repatriation flight back to your home country. Now, let's take a hypothetical situation. Let's say somebody enters the US as a tourist or student or whatever non-immigrant visa. And after they enter, whether it's the next week or months later or even a year later, they decide they now want to permanently reside in the US. That's perfectly legal. You can do that. But at the moment of entry, your intent must be to depart the United States after temporarily entering the United States. That's the legal standard that's applied. And there's a lot of confusion about the 90-day rule, and what that is an unofficial Department of State policy that's also been unofficially adopted by some USCIS offices that basically says if you enter as a tourist and you do something immediately within the first 90 days that suggests that you actually intended to permanently live here, like starting to work or applying for permanent residence, which is the ultimate evidence that you intend to permanently live here, then the burden shifts to you, the applicant, to explain your intent. But if you don't apply within the first 90 days for adjustment of status or otherwise take some sort of action that suggests you intend to permanently live here, then the burden is actually on USCIS, and in reality, it usually doesn't come up if the adjustment of status or permanent residence application is submitted out of that 90-day window from the date you entered on a non-immigrant visa. Let's look at another hypothetical now. Let's say that your immigrant spouse has a tourist visa and you go to her country and you guys get married. And then after you get married, your immigrant spouse is coming to the United States as a tourist. What do you think the intent looks like there to a customs officer? There are a couple questions that arise here. Number one, will the customs officer know that you're married? Probably not, unless they specifically ask you, are you married? Or where are you going? Or do you have any family in the United States? And then if you actually lie to the immigration officer, you're committing fraud, straight up fraud, and you should never do that. Another hypothetical situation. Let's say you're coming to the United States after marrying abroad, but you actually intend to just visit even though you're married to your US citizen spouse now, and then leave. That is perfectly legal. In fact, many people get married but are not able to move to the United States yet. So they'll just come and continue to visit. And I'm gonna make another follow-up video on this topic that I'm gonna release next week about traveling on an I-130. Traveling when you have an I-130 family petition pending, which creates a lot of the same issues that I'm discussing here. If you can prove that you are just coming to visit despite being married, That's perfectly legal. There's nothing fraudulent about that, as long as your intent is actually to leave. But if you're thinking about getting married and then coming to the United States to permanently live here, and your secret plan is to permanently live here, then that's fraudulent intent. Now let's take another hypothetical. Let's say instead of getting married abroad, you enter as a tourist and you get married in the United States after 90 days have passed. So the way this would play out is, I've seen this play out several times this way. You enter as a tourist, you have a long distance relationship with your significant other in the United States, but after this entry, your US citizen significant other proposes to you and you decide, you know what, I entered as a tourist and I don't have major obligations abroad. Why don't we just get married now and apply for permanent residence? That is perfectly legal. You can do that. And if that is what you decide to do, it's a good idea as soon as possible to speak with an immigration lawyer, like me, for example. And by the way, if you're new to this channel, this would be a great time for me to tell you to subscribe if you're interested in more topics like this. When I meet with people who just got married after entering on a tourist visa, presumably after 90 days have passed, I'll always tell them about the 90-day rule and what considerations to look for, what the process looks like with applying for a work permit or advance parole, and how long they should generally expect before they can travel. So just to sum things up, yes, you can get married abroad and continue traveling as a tourist, but it increases the risks of being denied entry. And if you're denied entry, there's a good chance you're not going to be re-entering on that tourist visa. And then we're going to have to do the whole process of becoming a permanent resident through a consulate abroad. It also increases the chance of immigration determining that you engaged in fraud. So it's not ideal. If you have multiple options, I wouldn't necessarily choose that option. With that said, if you do get married abroad and you're just coming to visit, bring ample evidence of your intent to depart the United States. That can include, at a bare minimum, a return ticket back home, which, by the way, many people have. It doesn't necessarily prove you're gonna leave. But obligations abroad, that could be like a medical letter from someone you're taking care of, like an elderly family member saying you need to go back to your home country, an employment letter showing you're actively employed and you're just given 1 month off to come visit the US, evidence of property that you have abroad, evidence of other obligations, like you have a dog and you need to give your dog to your sister for a month while you visit the US and you need to go back. You should bring all of this evidence in paper form. So when you're in the airport, if an issue arises and the customs officer begins asking you about your actual intent and they begin honing in on the issue, let's say they asked you, do you have any family in the US? And you say, yes, actually my spouse lives in the US. Red flag goes up. They're gonna ask you many follow-up questions, and it's important for you to bring evidence that your intent to visit is actually an intent to visit, temporary travel, and that you plan to depart, and evidence of all the obligations you have going on outside of the US. Doing that doesn't necessarily guarantee they're gonna let you in, but it certainly improves the chances in a dramatic way that you'll be allowed into the United States. I'll give you an example. I actually recently had a guy who is married and actually filed a family petition while he was residing abroad. And he wanted to come to the United States because his wife wanted to give birth in the US. His wife is a US citizen. She wanted to give birth here and he wanted to be here for the birth. And he brought a ton of evidence in the airport that he has all of these employment contracts abroad, he has properties abroad, he has family obligations abroad, he needs to come here for the birth of his child, but that he actually needs to leave within 6 months to return back to his home country, and he was allowed in. So it can definitely happen. I have several clients who've done this, but you really need to be prepared. And if you don't know how to prepare, you should speak with me so that we can create a plan. All right, guys, that brings us to the end of the video. I just wanted to make a quick video on this topic because I get this question a lot, and the answer is it's complicated. So I figured I'll just make a video on the topic. Whenever someone asks me it, I'll do my best to explain, and then I'll refer them to the video so that they can get a detailed explanation of what the situation is. If you have any questions, put them in the comments below. I'll answer all your questions for a week after each video posts. If you want to post a question after that week, you should find my latest video and post your question there. And again, if you're new to my channel, subscribe. I'll see you guys next week for another one.